Yeah, it is Lordship.
Yes.
Lordship, in item number 3, we have received written instruction from petitioner.
Item number 3.
Yes, Lordship, not to press the case any further.
When to be listed?
Well, they don't want to press the IA.
We have received written instruction from the petitioner not to press the case.
Acha. You want to withdraw this?
Yes, Lordship. Lordship allows to withdraw with liberty to file afresh if necessity.
Acha, your good name?
NZ Chaudhary,
Mr. So learned counsel appearing on behalf of
Mr. A.R. Bhuya.
Mr. A.R. Moya, learned counsel for the applicant, submits that he has instruction to withdraw this IA. With a liberty to approach the court again, if so advised. Pair is accordingly allowed. This IA is disposed of on withdrawal. However, liberty will remain with the applicant to approach this court again by filing appropriate petition or application. Yes.
Much obliged.
May I please, Lordship? So I beg to mention item number 4. Lordship, the engaged conducting counsel is in quarantine, Lordship, as his wife is in suffering from the pox disease. Item number 4. Kindly, my lord, letter may be fixed after one.
Mr. Your good name?
G. Boro,
G. Boro, learned counsel appearing on behalf of Mr.
S. Das.
S. Das, learned counsel for the petitioner. This shall list the matter on
After vacation, then.
After vacation. After vacation.
after vacation.
16th June, on the 16th July.
Okay, Mr. Your good name?
PD Bhuyan.
P.D. Bhuya, learned counsel for the respondent number 798 78910. And Madam
R. Gogoi.
R.
appearing
Gogoi,
on behalf of
learned
the
counsel for the respondent number
1, 2, 3, 4, 5, and 6.
1, 2, 3, 4, and 5 present. This is the matter after vacation. Okay.
For bail hearing, item number 1.
Much of this.
May I please, Lordship, the second bail application, Lordship. The petitioner was, Lordship, soon arrested on 1st April of 2024, Lordship.
So how many days you were behind the bar?
The base 17, Lordship, the soon arrest, Lordship, prayer for soon arrest.
No, my question is for how many days you were behind the bar?
Yes. 6.
58 days, Lordship.
50?
8 days.
What is the mandatory period of detention?
60 days, Lordship.
Yes, any instruction?
CD receipt, Lordship.
What is the state
Evidence has collected, Lordship, some
collected?
Length of period.
Investigation completed or not?
not completed.
Not completed. But
Investigation.
material part is over.
Almost, Lordship. Probably in this case, Lordship, on last occasion, one person, co-accused has been released on bail.
3 accused arrested in
On
this
last
case.
day before
They are
yesterday.
released on bail.
Heard Mr. Enamed, learned counsel for the accused, and Mr. P.S. Blocker, learned additional PT for the state respondent. This application under section 439 services preferred by accused, namely Aminul Haq, who has been languishing in jail as of since 1/4/2024 in connection with Pata Circus APS case number 59 of 2022 under section 420 379 IPC, for grant of bail. It is to be noted here that a convicted case has been registered on the basis of one FIR lodged by. Where is the order? First order?
The Lordship base 42, Lordship.
So para number 3, page 42. Mr. Ahmed, Learned Counsel for the accused submits that this is the second bail application preferred by the accused. And the first application being BA number 1457 of
Right.
2027 was dismissed by this court by order dated 27/5/2024. Mr. Ahmed further submits that the ground for filing this second application is, what is the ground?
So Lordship, his wife is 8 months pregnancy, running Lordship.
Submits that wife of the accused is suffering on is in the family way. And there is none to look after her. And that one of the co-accused has already been enlarged on bail by this court by the order dated. Where is that order?
Lordship is 21. Yes, 18 onwards, Lordship. 3 accused. Already.
Some of the co-accused have already been enlarged on bail by this court by order dated 17/5/2024 in BA number 1403 of 2024 and BA number 1207 of 2024 and that and BA number 1457 2024 by order dated 27/5/2024 and that present accused is also stands in the same footing and that he is ready to cooperate with the investigating agency and therefore Mr. Ahmed contended to allow the petition. On the other hand, Mr. P.S. Lokur, Learned Additional PP, has produced the case before this court and submits that though the investigation is yet to be completed, yet material part of the investigation is almost over and that the accused is languishing in jail as of for 58 days. But having heard the submission of that line, the case diary indicates that material part of the investigation is almost over. The accused is languishing in jail as of for last 58 days. 58 days, and that some of the co-accused have already been enlarged on bail by this court in BA number 6, which but report is good. In view of above, this court is of the view that further custodial detention may not be required in the interest of investigation, and therefore this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 50,000 with conservative like amount to the satisfaction of the learned CM
Bozali Patchala.
CM Bozali Patchala, the accused be enlargement base.
Instead of 58 days, it will be 57 days. Lordship.
57.
It will be 57 days. Lordship.
Okay, 57.
Deeply obliged.
Numbers 2, 6 and 7.
My lord, item 2, second time bail application, my lord. Only, my lord, 52 days, as in today. Evening, earlier his bail was rejected by this court. This order is, my lord, is
You are in item number 4.
item 2, my lord.
2.
Yes, my lord.
I think to Lordship. This is Lordship that dial packet.
Packet government.
In item 2 Lordship, there is a ion Lordship that this person is not Asikul Haq.
Yes.
Asikul Haq is the owner of the godown
Yes.
and he is the servant in that in his
Yes.
under him Lordship. It
I
is
am
Asikul
labor.
Islam Lordship. Labor Lordship. Asikul Islam Lordship.
Earlier,
The
it is
ion.
wrongly mentioned that articles first kept in the godown of Asikul Islam. Actually, it is Asikul Haq.
Asikul Haq is
He is the man. He is the, in earlier order also, Lordship also find that Asikul is the main persons. Page 30. He Lordship person order earlier,
So
Yes.
on the other day, Mr. B. Sharma appeared.
yes.
He submits that
Asikul is correct. He is also correct. It is, I don't
And
know.
that is reflected in the case
Yeah,
diary
Yes, yes,
statement also.
Ashikul Islam, yes, it is correct. But now the IO, actually, I mentioned in my petition that a report may be called for from the IO, that I have labor, my lord, I have no house at all, my lord.
Here is a specific note, Lordship. I have not, Lordship. Wherein he is stated,
In the
Lordship.
CD.
Yes.
Lordship. Herein is it stated, Lordship, Asikul Islam,
No,
son of,
this is a new note.
No,
no, no, 3-6, Lordship.
Acha.
So today 52 days I am in the university. I'm the labor,
So where is the first order?
yes, lordship, this is annexure page
20?
20, madam.
Next are 4.
Yes, page 20.
Okay, heard Mr. J. Ahmed, learned counsel for the IQs. And Mr. P.S. Lawson, learned additional duty for the state. West Bengal. Pair number 20, page number 21. Mr. Ahmed, learned counsel for the accused, submits that this is the second bail application prepared by the accused, and the first one being BA number 1481 of 2024 was dismissed by this court on 29/5/2024 after perusing the case date. Mr. Ahmed further submits that though the earlier bail application was rejected after perusing the case diary and having found sufficient materials against the accused, yet in fact the accused is a daily wage earner and he has no Gudam at all, and he is behind the bar for last
52 days, as of today.
52 days. And that he is ready to cooperate to the investigating agency, and therefore Mr. Ahmed contended that the accused may be allowed to go on bail. Whereas Mr. P.S. Kokor, learned additional PP, has produced the case diary before this court, and referring to a note of the IO of this case, Mr. Lokor submits that in fact, this present accused is a daily wage earner, and he has no Gudam at all. And what is the stage?
Materials are not recovered all, Lordship, and but some evidences are collected, Lordship. Recorded,
And
Lordship.
further, Mr. Locker submits that though some of the materials are yet to be stolen materials are yet to be recovered, yet the IO has collected some evidence in the meantime. But having heard that line, the case diary indicates that the IO has achieved some progress in the investigation of this case. Further, it appears from the case diary that the present accused was working as a laborer and he has no Gudam at all. Though in the earlier though earlier he has reflected in the case diary that the present accused has one Gudam in his name, where the stolen articles are stored. Further, it appears that the accused is behind the bar for last 52 days. And in view of above, especially the period of detention, further custodial detention of the accused seems to be length of detention or further custodial detention seems to be not warranted, and therefore this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 50,000 with 1 share retail line amount because restriction of the learned.
Sejam oh, sorry, Sejam Metro, Kamrup Metro.
Season Kamrup M, the accused and
Oh,
learned.
that's it. As of yes.
I think 6 and 7.
My lord, seven, my 6. Let's go.
May I please, your Lordship. Second application, Lordship.
Lordship, the earlier order is on page number 21, Lordship.
Oh,
On
how many
material-
days you are behind the bar?
Lordship, two petitioner are here. First petitioner is 48 days behind the bar, and second petitioner is 52 days behind the bar.
But as per serial, these two persons are main game planner also. They plan entire again.
So what is the ground for filing this second application?
Lordship, since I have been, both the petitioner are languishing in the behind the bar for last 48 and 52 days. Investigating officer has not visited the jail as a single time for any custodial interrogation. And we have been thoroughly interrogated. We have been in the police custody. After that, no custodial interrogation is there. Materials are there. And we are local person, Lordship.
Where is the guarantee that if we enlarge you on bail, you will never commit any offense again?
Lordship, any condition, any stringent condition may be imposed, Lordship. We'll abide by the condition, Lordship.
Yes, Mr. Lawford?
Lordship, they have and played in the entire game, Lordship. Then they have also admitted, Lordship, in this case, Lordship. And one person is yet to be arrested, Lordship.
Who?
The Siddiq Sikandar, Lordship.
The second I filed.
Not one person, Lordship. 2-3 persons are there, Lordship.
What is the punishment for the offense under section 407?
It is mandatory period is 60 days, Lordship. 7 years imprisonment, Lordship.
To tell.
Yes, sir.
Yes, Mr. Lawford, behind the bar for 52 days.
Considering the length of detention, Lordship, and we will abide by the.
No, whether the second petition is maintainable on the ground of length of detention.
It's already.
Is it? Is it a change of circumstance in your favor?
Lordship, no custodial interrogation has been done by the investigating officer till date, Lordship.
Heard, Mr.
D. Medhi, Lordship.
Learned Counsel for the accused. And also heard Mr. P.S. Lawford, learned additional duty for the state respondent. This application under section 413(9) services prepared by accused Sahadev Rava and Pranav Borwa, who are languishing in Jailazut in connection with Hazara PS case number 85 of 2024 under section 407 rupees. After this, page number 21, para number 3. Mr. Medhil, learned counsel for the accused, submits that the first bail application for the first bail application being BA number 1496 of 2024 was dismissed by this court by order dated 29/5/2024 after perusing the case date. And after dismissal of the first application, more than uh, 15 days over, and the accused are behind the above for last 46 and 53 days respectively. And they're ready to face trial and will cooperate with the investigating agency, and therefore it is contended to allow the petition. Whereas Mr. Lawford, learned additional duty, referring to the producing the case data before this court and referring to the materials available against the present accused, submits that they are the kingpin of the offense. However, Mr. Lawford submits that the IO has the investigation is going on and the IO has collected evidence. IO has examined some witnesses and also collected some documents, but they recovered some materials, but some of the materials are yet to be recovered. And therefore, Mr. Lawford, learned additional PP, has opposed the petition. Having heard the submission of learned advocates of both sides. That's right. The case study indicates that the IO has achieved some progress in the investigation of this case. Both the accused are languishing in jail for last 48 days and 52 days respectively. In view of the progress of investigation, as well as the length of detention, further custodial detention of the accused seems to be not warranted here in this case, and therefore this court is unfair to allow this petition. It is provided that furnishing bond of rupees 50,000 each, with one which is likened to the satisfaction of the income of head. The accused is less than that.
Highly obliged, Lordship.
Seven,
In this case, this petitioner, in his position, 155 bags of dal has been recovered. I'm the person, my lord, I passes it from that Ashigul Haq. Ashigul Haq he is the distributor, my lord. Not only for that purpose, earlier also he is the distributor. So I purchased, I am and my brother Azizul Haq.
For how many days you were behind?
No, I am not in disability. My brother was
So this is
arrested
a-
along with, my brother was arrested along with that article. And he was released on bail by this noble court. Is this, my lord?
200 bags was
One page,
So this
19 years
person is
old.
a Sikandar Ali.
Yes, second. And main accused is Ashikul Haq, he is not arrested. He supplied
Wha-
this articles, my lord.
no, Lordship. This Asif, this Sikandar has received directly from those persons, from the truck driver and
Who? This Sikandar.
Lordship. They have di-
This applicant has purchased the same from
Yes,
Hodev
yes.
and this
Yes. So,
Arnav Barua.
so my lord, ultimately, section 411 will attack on me, my lord.
Hmm?
I actually passes the stolen property. So 411 attacked on me. So 3 years.
and that case,
Punishment.
Lordship, with this
Punishment is 3 years.
that tomorrow Asif will again will come, Lordship, that he is on the same footage, Lordship.
Well, only fact is this, my lord, Lordship kindly see that in the what happened, after my brother Anizul Haq was arrested on 22, along with the 155 bags of dal recovered from our positions, our shop. We have a shop, my lord.
Mr. Locker,
Lordship.
can I see the case there?
Yes, my lord. Then, my lord, what happened? That while my brother was arrested, my mother suddenly expired on 24 after heart attack. My one brother arrested. On heart attack, my brother mother was expired. So
No,
by
on that ground, we have
already my brother. Now,
Now there is no such circumstance in your case, in
no,
the
yes,
present application.
I am the brother. My brother was expired, but put it as work. Religious work is today, yesterday, and today also going on, my lord.
It is over.
It is today, it will go over, put it as
It is
religious work, my lord. So, my lord, I am not a stolen the articles.
No,
It
no.
is correct that I purchased and those 155 bags referred from my body. And my petition, I paragraph 7, I specifically mentioned that I purchased those item from Ashigul. Ashigul has distributed those articles along with that those persons. Well, so I will cooperate. I can help also to recover the other articles, my lord. Main person is the driver and that Ashigul and handyman arrested. If you also can see a statement of the driver, what involved, my name has not been disclosed.
Again, bro. Discuss going to no, but again.
Nama kita spesial. So, for the No possibility. Purnab Barua is the person driver. You will also is the statement of Purnab Barua.
Materials are there against you.
My lord.
You go and surrender, thereafter we'll see.
My lords. And some observation, my lord,
Regarding,
he will consider my bail application by
No, no.
considering.
no such observation.
And
Hard. Nagotan sina ikate. Accused are not seeking for Mr. Ahmed learned counsel for the accused submits that the
My
applicant
mother expired, that
applicant
down
is
the
the
court will may
brother.
consider my. Paise. Political appeals. Huh? কালি ষ্টেটমেন্ট প্ৰণৱ বৰুৱা my lord. He is the main person.
Specifically in the person.
I have a shop at Bravo Bazar. Go to give it.
Where is the order by which your brother was granted by?
Yes, that is my lord.
Page number 26.
Page number 19, my lord. Page number 19.
Mr. Ahmed submits that the present applicant is the brother of Mohammed Azizul Haq, who the present applicant is the brother of Mohammed Azizul Haq, who along with said Azizul Haq had received 200 bags of stolen articles. At the instance of accused
Asikul Haq.
Asikul Haq, and that he is no way involved with the offense alleged in the FIR, and he is ready to cooperate with the investigating agency. In that his mother has already suffered demise, and religious function is going on, and therefore Mr. Ahmed contended to allow this application. On the other hand, Mr. Law Court learned additional PP submits that the IU has collected sufficient incriminating materials against the present applicant, and from his and his brother's godown, 200 bags of stolen articles were recovered and seized by police. And that his custodial interrogation is required in the interest of investigation, and therefore Mr. Law Court has opposed the petition. Therefore, having heard the submission, the case here indicates that the IU has collected sufficient incriminating materials against the present applicant. Investigation is going on, and his custodial interrogation seems to be indispensable in the interest of investigation, and therefore this court is inclined to. No, this court is of the view that this is not a fit case where the privilege of PRS bail can be granted to the applicant. And accordingly, the petition is dismissed, case will be returned.
Hello, Alex.
Article 5, further matter.
Yes, Mr. Locker, you have gone through the case ID?
I have gone through the city lordship.
Hmm.
Case date. Here on last occasion lordship, here in this case lordship, the main fee is that lordship in 161 nobody has implicated him.
Hmm.
Lordship. And on that one I took time lordship. that whether the non-implication of the accused in 161 will be a ground for set aside quashing the entire proceeding, Lordship. Lordship, here
No, this is against the order of framing search.
Order of
that is, Lordship, that is
against charge.
against search, Lordship.
Yes, if there is no material, how the search frame against him will sustain?
Lordship, here in this case, Lordship, in 161, Lordship, it is not like that nobody has implicated him. There is the implication is there, Lordship, that because of him, she got suicide. She got suicide, Lordship. And the entire thing will come during trial, Lordship, because as Lordship, in case of if in case of 161, Lordship, if we go to the for conviction, Lordship, we cannot give any conviction on the ground that he is admitting in 161, Lordship. Then at this stage also, if he is not, nobody implicates directly implicates this person, and on that term, Lordship, acquitting that person or
No, no,
quashing-
what kind of argument you are advancing, Mr. Thakur?
merely on the ground of non-implicating in the 161, Lordship.
Then how can you frame search?
Because Lordship, there is some
Okay,
implication.
none
Only
of
it is not
the-
like that, Lordship. There is no any implications, Lordship. Implications are there, Lordship. In 161 statement, if you, Lordship, kindly go through the same implication, Lordship, that their father has stated, Lordship, that she has implicated, Lordship. She got suicide on because of him, Lordship. And there is also, Lordship, one CDR report is also there that she talked with him, Lordship.
CDI report.
Lordship.
That was
And-
not provided with the charge sheet.
Have you enclosed the same with the search sheet?
Charge sheet does not state so.
Not
Then if you fail to enclose that CDR with the search sheet, how can you introduce the same in the later stage of the trial?
Lordship, on during trial it will come, Lordship, because Lordship, may I place
How?
in that case, may I place one record, Lordship, wherein it is stated, Lordship, that only non-implication of under in 161
Hmm.
the case will not go, Lordship. Para 22, Lordship. Here, this case is relates to a mob attack, Lordship, and there are 2 persons died, Lordship. In the entire 161 statement, Lordship, nobody has implicated nothing, no one, Lordship. And that here, nobody has identified, nobody has implicated no one, Lordship. But regarding in one PW 10 and 13, Lordship, during evidence test, Lordship, they have implicated, they have stated, they said these persons I have seen, Lordship. So regarding that, Lordship, this case is, Lordship, and in para 22, Lordship, it is stated, Lordship, that mere fact that the applicant was not named in the statement made before the police under section 161 CRPC, and due to this omission, the evidence of PW 10 and PW 13 rendered in the court is unreliable, cannot be sustained. Statement made to the police during investigation were not substantive piece of evidence, and the statements recorded under 161 CRPC cannot be used only for purpose of contradiction and not for corroboration. In our view, if the evidence tendered by the witnesses in the witness box is creditworthy and reliable, that evidence cannot be rejected merely because a particular
No,
statement made by
that was considered at the end of trial.
Lordship.
This is
Because, Lordship, and
in appeal.
in our case also, Lordship, if we go through this judgment, Lordship, in our case, if trial could not be proceed, Lordship, and in this case also, Lordship, when it is mentioned here, Lordship, that nobody has implicated no one, Lordship, then also, Lordship, cognizance was taken, Lordship, and Lordship, search frame, Lordship. search frame and the trial proceed lordship. And in this case also let the trial be proceeded with lordship. If there is no witnesses come forward, no witnesses do not implicate during trial also, then it will automatically they will be acquitted lordship. But without going through the trial lordship, and here it is specifically said lordship in 161 statement, if we cannot convict on the basis of 161, how we can acquit one person only on the basis of 161 lordship. And it is not like that. There is no one said nothing. Yes, someone
No,
two
Mr.
witnesses said-
Locker, the principle is there must be material to frame charge against him. If there is no material, then how can? This is this observation is made by the Supreme Court in different contexts.
And I have given also 2010-12 SCC page 190. I've already supplied them. 2010-12 SCC page 190.
fact is same lordship. The context is also same lordship here in this case lordship, that no, when nobody has implicated no one, but in during trial they have implicated this person lordship. So lordship 10, PW 10 and PW 13 they have implicated this person lordship. Then this this equation arises and this observation come up lordship. And if we do not start this trial lordship, how we can come to know what will say?
So you are referring to which judgment?
I know 2010-12 SCC 190. SS Chinna versus Vijay Kumar Mahajan and other. 2010-12 SCC. Was actually the first judgment I gave your lordship.
Okay.
My lord, there, if your lordship takes up paragraph 27. Instigation, abatement, there, those points are dealt, but in general, paragraph 27, second last paragraph. When we carefully scrutinize and critically examine the facts of this case in the light of the settled legal position, the conclusion becomes obvious that no conviction can be legally sustained without any credible evidence or material on record against the appellant. The order of framing charge against under section 306 IPC against the appellant is palpably erroneous and unsustainable. It would be travesty of justice to compel the appellant to face a criminal trial without any credible material whatsoever. Consequently, the order of framing charge under 306 against the appellant is quashed, and all proceedings pending against him are also set aside.
Okay, we will see.
And as per the CDR, my lord, page 54 of my petition, the charge sheet, it mentions what has been seized, what has been provided.
Pardon, Mr. P.S. Locker, learned additional duty to the state respondent and Mr.
Your lordship, D.S. Teka, appearing on behalf of Mr. T. Theory.
So, on behalf of Mr. T. David. Argument of Mr. Locker completed. Mr. D.K. Bhattacharya, learned counsel for the petitioner present. Order is
Obliged.